basically, in terms of the assurances that people are hearing about, basically, the US recently provided diplomatic assurances to the UK High Court to prevent a final appeal by Assange against the extradition. So they promised that there would be no prejudice with respect to his nationality. And they also promised that there would be no death penalty sought or imposed. And third, they promised that he can raise First Amendment protections, and those are all problematic. I call this human rights theater, basically, starting with the death penalty, because Assange is not charged with a death-eligible offense. Also, it has taken 5 years for them to issue this assurance. And basically, that has to do with extradition law, which is not my area of expertise. But basically, under extradition treaties, countries will not extradite to other countries where the death penalty is a risk. And that's why they were taking that off the table. But it was never on the table because it's not a consequence of the 17 charges that he's facing. In terms of the very idea that he can seek to rely on a First Amendment defense, it's really a bunch of bunk. He can seek to rely on a herd of goats if he wants. He can seek to rely on anything. Anyone can raise anything as a defense. So it's very disingenuous to use that. I think that's what Stella Assange, his wife, meant by it being kind of a weasel word, that he could seek to rely on a First Amendment defense, because it's also very disingenuous because people who have tried to raise First Amendment in these cases, the US has specifically, in a number of different Espionage Act cases, done motions not only to preclude a First Amendment defense, but to preclude even the word First Amendment, even those words, and to preclude the word whistleblower, and to preclude the word journalist. So it's very slick and dangerous to kind of say that he can raise a First Amendment defense. He can raise any kind of defense he wants. That's always been his prerogative. But the thing is, in these cases, they are strict liability. Whether or not he disclosed the information, possessed the information, did he or didn't he have this information? His good intent in doing so is not allowed to come in during the case in chief. It would only be allowed to come in during sentencing after he had already been found guilty. So to the extent he wanted to talk about First Amendment, based on my experience, that would be something he could only really talk about at the sentencing phase, because the government would certainly file motions to preclude anything based on the First Amendment during the preliminary motions phases, and would do that quite vigorously, and has done that in pretty much every Espionage Act case against a whistleblower. And yes, there is a distinction because, of course, Julian is a journalist, but him being a journalist is crossing the Rubicon. It was bad enough that this law has been used against whistleblowers, but I always said the war on whistleblowers is a backdoor war on journalists. And here it's coming to full fruition with Julian Assange. And it is going to radically alter the landscape of press freedom in this country if Assange is in fact extradited.
We have to celebrate those